Okay, so looking at domestic succession, which is the last part of the domestic slides. So here we have the situation where Akash actually passes away, survived by Sapna and Anika, the daughter. And the question that we'll ask is, the basis on which Indian succession law would apply, was it nationality, residency, domicile, situs? How does Indian succession law apply? And does Indian succession law contain forced heirship rights? So this is quite a critical question. Does it permit full testamentary freedom, which is the reverse of forced heirship? And then does an Indian succession law permit what we call financial dependent claims? So people that were dependent on the deceased, are they able to challenge what was in the will, or are they able to make claims for financial maintenance post-death? So Shreya, if you can take us through from the Indian succession aspects.
Sure. So the general principle on Indian succession is that movables are bequeathed as per the domicile of the individual, whereas immovables bequeath based on the situs. So what that means is, if it's a non-domiciled, non-Indian domiciled person who owns real estate in India, or if it's an Indian domiciled person who owns assets wherever that person may own these assets, in both those situations, Indian personal laws would apply. Indian succession law may contain forced heirship rights. It would depend on the religion of the person. So, for example, if the person is a Muslim, then forced heirship rights would apply under Sharia law applicable to Muslims. But for most other religions, we don't have a concept of forced heirship. I should caveat that for Hindus, there is a concept called the Hindu undivided family, which is it's a form of collective ownership of property, which could impose restrictions on free bequeathal of property, similar to what you may find in the context of forced heirship. But it's not an apple-to-apple concept, but it would need to be evaluated. So aside from these situations, Indians would generally have full testamentary freedom. And there wouldn't be restrictions in terms of having to leave the property to relatives, for instance. And there would also be restrictions on financial dependence from being able to make claims, assuming that the will has been made validly if there is a will, or assuming that there's an interstate succession, in which case we have legislated rules which apply.
Right, okay. So from the UAE perspective, the question here is, obviously Akash has passed away, and he held prior to death shares in a UAE company, and he'd also settled a trust. So the question is, would an Indian will be recognized and enforced in the UAE? So this is a will that was executed in India, so it's not a UAE will as such. Which succession law will apply to the company shares if Akash dies without a valid will? So he didn't have a will at all. And then can the validity of the DIFC trust be challenged on the basis of foreign succession law rights?
Well, before last Saturday, my answer to this question would have been, an Indian will would never have been valid in the UAE regarding an onshore or an offshore asset in succession. So, but since Saturday, and the new laws that have been introduced in the UAE regarding many issues, and one of them is succession planning, a will that is valid, entered, executed, and valid in the country, or whatever country the deceased has had before death, would be valid in the UAE and would be executed in the UAE upon the law of the country where the will was issued. So this is a new thing for us. And now I can say easily, a will save the day for every expat that is living in the UAE with assets in the UAE. Now there is a bit in the same media release on these laws that said, save for the UAE assets. That leaves us also in a shaky situation. But I would say probably that the better way would have been to have a DIFC will to cover the assets, including whatever would have been in India. So it would have to be a unified will in a way of two jurisdictions. However, now the will is not there, and Akash has passed away without a will. What would happen as far as a DIFC trust, and would it be challenged on a foreign succession law? Again, the the default situation would be not because of the firewalls that are already in the trust law. However, and again, bearing in mind that the Indian laws, as far as divorce are concerned, not necessarily divorce here, sorry, Shreya, the succession planning, I'm not really sure how would they have been as far as religious issues of also in India. So the idea is that foreign judgment in India, if in any way is for a Muslim, that would actually be implemented immediately in the UAE onshore. That would have made it much easier. And if it's not a Muslim, that we would have again to go with the Sharia route. So we're not really sure how would it be after Saturday, except for the DRC trust. I would say that we would still go with, if there is a community property with the wife, that would prevail here.
Right. So, Diane, if I understand you, when we look at Akash's shares of the company, he died without a will. And so there's nothing in the UAE under the new law to attach to. Are we saying at the moment that it's uncertain how that situation will be played out? Or would it be you apply the old rules of just, well, you apply Sharia law to it, regardless of his religion, or how does that work?
We don't really know, but they say the law of the deceased. So it may be the Indian laws,
right,
but we don't really know how it's going to be as far as the Sharia, which is again a public policy, would be the stand then.
Right, okay. All right, so just moving on, there's no tax implications, so we don't need to worry. In terms of the US side, so would an Indian will be recognized in the US? Which succession law would apply in the US if Akash dies without a valid will? And which succession law will apply to US land if Akash dies without a valid will, India or US, and then the local tax implications? So, John, if you can run us through that quickly.
Yeah, just as we touched on with the divorce concept, remembering on succession, the important point is that there is no federal element of that. That's going to be regulated on a state-by-state basis. The first analysis is exactly what your questions map to. Is this intestate or testate succession? It's why we always say if you're going to hold U.S. assets, at a minimum, you want to have one will for common law jurisdictions and one will for civil law jurisdictions. Maybe you go with one will for the particular property in the US, depending upon the other common law jurisdictions that are involved. So would a will be recognized in the US? But potentially, you want to be careful about some of the little nuances of how things are taxed versus wrapped. So we can use testamentary trusts and some other shielding actions before time in a planning effort to shield against US estate tax exposure, local transfer tax exposures when it is the offshore company shares that are being exchanged when the person dies rather than the property in the US, movable or immovable property. So yeah, keep in mind local tax complications, state by state. The most onerous is California, and we'll touch on some of those particular details in the next section about US specific planning.
Okay. And then looking from the UK, I'll cut through this fairly quickly. With Indian will be recognized if it's properly executed under Indian law, domicile of the individual, then that will be fine. So if it's valid in India, then the UK will recognize that. When succession law will apply to Akash's, which succession law will apply to UK investments if Akash dies without a valid will? Well, in the UK, what will happen is it will default to the domicile. So it will be Indian law that will cover the succession to his movable assets in the UK. And then on the land, it will be UK law that covers that. So UK intestacy rules, and then the Indian intestacy rules will apply to the movables. And then the tax implications, this is going to be an inheritance tax issue, potentially, depending on the values of the assets and where they go. There's no double tax treaty on the inheritance tax side between the UK and India. India doesn't have an inheritance tax law yet. So there's no issue there. In terms of the exposure, though, it will, as I say, all be down to where the assets go. Does it go to SUPNA? Or alternatively, is the assets going to go elsewhere under the intestacy rules, particularly? So that will drive the inheritance tax treatment, but there would be, depending on the values, an exposure to UK inheritance tax in this instance.